can you hear me? I can't hear. I can't hear you. Yep. Can you hear me now?
Yeah, I can hear you, but oh, can you hear me now?
Yep, I can hear you now. Um,
Okay, perfect. Sorry about that.
okay, what's your name, please?
Lisa Johnson.
Lisa, are you the victim?
Yes.
Okay, thanks. Is it for is that what it is? Deonta Johnson?
Justin Johnson.
Justin? Oh, got it. Okay. That's at 8:30, so I'm just gonna leave you where you are and just keep yourself muted.
Okay, perfect. Thank you.
You're welcome.
34th District Court, Register of Action.
Good morning, Mr. Braxton.
Good morning.
Is your client with you?
No, he's not. I just
This
texted
is,
him.
I'm sorry. This
I
is
just text-
220775 SM. This is State of Michigan versus Justin Michael Johnson. I'm sorry, Mr. Braxton, you were starting to say you just texted him.
Yes, I did to see if he was on. Haven't received the response yet.
The reason that I came out and called the case is because it was scheduled this morning at 8:30 for sentencing. It is now not 8:45 by this court's clock. The policy and practice of this courtroom is 15 minutes after the scheduled start time. The victim in this case, Lisa Johnson, is here and has been on for almost a half an hour now. I don't like to keep people any longer than is necessary.
Can you give me 1 second? I can try to call him again.
Absolutely.
Okay, thank you.
Ms. Johnson?
Good morning.
Good morning, ma'am. How are you?
I'm well, Your Honor. How are you?
I'm good, thank you. Mr. Braxton?
I've made 3 attempts. The phone calls are going straight to voicemail, Your Honor.
Thank you. Today being the day and time set for sentencing in this matter, scheduled at 8:30, is now 8:49 by this court's clock. The court will deem Mr. Justin Marcel Johnson as having failed to appear for the duly scheduled sentencing. Bench warrant shall issue in this matter, 5,010%. Anything else, Mr. Braxton?
No, Your Honor.
Thank you very much, sir. Have a good day. Ms.
Thank you.
Johnson?
Yes, Your Honor.
At the time that Mr. Johnson entered a plea in this matter, there was a request for restitution from the prosecutor of $50. This court had not received anything else from you. Ma'am, if this matter is rescheduled and there is a request for restitution, please respond to probation department and provide receipts or your written request for reimbursement or restitution, okay?
Okay, thank you.
Thank you for your patience this morning, ma'am. You have a good day.
Yes, you too.
Thank you.
Good morning, Josh. How you doing?
Good morning. I'm a little
Hi.
early, I think.
Yeah, that's good though. Because Miss Freeman is here. Do you need a breakout room with her?
Yeah, sure.
Okay, I just made you co-host.
Cool, thank you.
You're welcome.
There we go. Let me go grab my sheets from Tony real quick. All right. Good morning, Miss Freeman. I'm going to move you into a breakout room real quick and we're going to talk. Give me 1 second.
Okay.
Good morning, Mr. Braxton.
Good morning. We were just on, I just spoke to my client. He said he was already on Zoom and is actually still on Zoom, and he had checked in, he had checked in at 8:30, but he's only under the name JUS.
They're not in our courtroom. You must be in another courtroom.
Uh, okay. All right, I'll let him know.
Okay,
Thank you.
you're welcome. Hey, Mr. Hadley.
Yes.
Mr. Nickel is here also. Do you need?
Yep. I'm going to move Mr. Nickel into my meeting room.
Thank you. Hey, Josh, was that enough time?
Yep, we're good. I've
Okay,
met
thank
with
you.
with
Oh,
Miss
glad to-
Freeman and Mr. Nickel. See Mr. Charles Cutter. Has Mr. Cutter asked for counsel?
He has none, Attorney Nunley. I don't know if you're gonna, you want to
Yeah,
grab.
I'll cover for that one today. Yep,
Okay, all right. Thanks.
absolutely. Let me see. Mr. Grant. Let me see if I can get Tony to shoot me over the sheet for,
Yeah,
hey,
I'll
Mr.
check
Grant.
with,
I'm going to cover for Royce on Mr. Cutter this morning. Do you happen to have his violation sheet?
I just sent it over to you about 5 minutes ago, Josh.
Sweet. Thank you, guys. Ah, my bad. All right, Mr. Cutter, I'm going to move you into a breakout room with me, okay? Just accept the
Okay.
invite if you see it.
Your department, I think, stated.
Mr. Hadley, it looks like yeah, you just saw what I saw. Okay.
Mr. Johnson, I'm going to move you into a breakout room with me.
Thank
Okay.
you.
All right, am I in the room for Judge Martin?
Yes, you are.
Thank you.
Yep. Mr. Johnson, I see that Mr. Braxton is not back on. Can you please contact him and have him join the Zoom so your case can be called?
Yes, I will. Thank you.
Uh-huh.
Mr. Braxton will be joining shortly.
Hey, Mary Ann. I see
Yep.
on the docket today, a Brandy Davis as a 9:30 show cause.
Yes.
Don't have anything for her. And I do have a sheet for Sheena Taylor, but I don't see her on the docket.
She is on the docket. Oh wait, you know what? Actually, she's coming in right now. Do you need information on her?
No, I have information on her. The only one I don't have would if she joins is Brandy Davis.
Okay.
All right, Miss Taylor, if you can hear me, I'm going to move you into a breakout room to meet with me real quick.
Okay.
Hi, the person who just signed on and identified as iPhone 12, what's your name?
Brandy Davis. I'm sorry, I meant to put it in there.
Thank you.
Full of ideas and you can't deliver, okay? You know, you're ready to break out and you can't deliver.
Hey, Mr. Hadley, Brandy Davis did appear.
I see Ms. Davis. All
Yep.
right.
Josh, I just sent you an email for her.
Okay, thank you, Mr. Grant.
Mr. Braxton, I did not know that you were back, but if you're ready, I'll recall your client's case.
Yes, I'm back and I'm ready.
This is a recall of 220775 SM. This is State of Michigan versus Justin Marcel Johnson. May I have your appearance, please?
How you doing, Your Honor?
Good morning, Your Honor. Chief Braxton representing Mr. Johnson.
State your name, sir.
Justin Johnson.
Mr. Johnson, your case was previously called at 8:49 a.m. as it was scheduled for 8:30. I'm recalling it now. Mr. Braxton, are you prepared for sentence to be imposed on your client in this matter?
Your Honor, I didn't receive the pre-sentence report. I don't know if it was sent to me.
There was not a pre-sentence report, sir. The reason why it was scheduled for sentence versus sentence being imposed on the day of the plea was to give the victim an opportunity to appear and be heard. She was here at 8:15 this morning. The court released her when your client failed to appear as directed.
Your Honor, when I was here earlier, I did try to call him, but it was on his old telephone number. After talking to his mother, I was able to obtain the right telephone number. Mr. Johnson did say he had been on under JUS since 8:30 this morning, but obviously it did not show up. He said, I believe he says he was in some sort of waiting room.
Mr. Braxton, respectfully, we're past that point. Mr. Johnson was not in this court session. I was out here personally. He was not in our waiting room. I'm prepared to proceed with sentencing this morning. If there's anything you'd like to say on behalf of your client.
No, Your Honor.
Thank you. When the parties were here originally, Mr. Johnson had been charged from November 30th, 2022 for illegal entry. There was a plea made on February 14th, 2023 pursuant to 771.1. The recommendation and with the agreement between Mr. Braxton and Ms. Mandernock on behalf of the people were 12 months of probation, batterers counseling, restitution to Ms. Johnson in the amount of $50 of the continuing order that he do not return to the resident to 16433 Taft Street, that he have no contact with Ms. Johnson except for that which was necessary for parenting time. The court will adopt the agreement that had been previously reached by and between the parties and will impose a fine of $500, cost of $200, their $75 mandatory crime victims fee, $50 mandatory state cost, $20 fund fee, $15 administrative fee. There was $50 of restitution requested on behalf of the victim previously. When Ms. Johnson appeared this morning, the court advised her that if she had additional requests for restitution, she needs to submit those to the court in writing. She has an absolute right to return to this court if the $50 requested by Ms. Mandernock is not sufficient. If your client, Mr. Braxton, needs assistance in getting set up for batterers counseling, the probation department will be in contact with him. There will be paperwork for him to sign to put the sentence formally in place. Was there anything else you'd like to say on behalf of your client, sir?
No, Your Honor.
Thank you. Mr. Johnson, good luck to you, sir. Listen, the court wants you to be successful on probation. Please be compliant and responsive to outreach from the probation department to get your counseling set up, to get payment arrangement made on your fines and costs. If there's anything else you need to be successful over the next 12 months, do not hesitate to reach out to them, okay?
I sure will. Thank you, Your Honor, and I apologize for my tardiness.
Thank you, Mr. Johnson. Have a good day.
You too.
Thank you, Your Honor.
Thank you. Thank you, Mr. Braxton. Mr. Cutter, please remove your cap. This is 210813 SM. This is State of Michigan versus Charles Adam Cutter. May I have your appearances, please?
Charles Cutter. Good morning, Your Honor. Attorney Josh Hadley, on behalf of Probationer Charles Cutter.
Thank you. Today is the day and time set for the violation hearing. Mr. Cutter, this court is in receipt of information from the probation department that indicates that you have been non-compliant with treatment and education, that you provided documentation of completing a 12-week anger management course, but the court was ordered you to complete a 26-week batterers counseling. You are also ordered to pay on the fines and costs that have been assessed previously. You have not made a payment since July 11th of 2022. You've had no new criminal offenses and no new entries onto your driving record. Mr. Hadley, what do you say on behalf of your client regarding these violations?
Your Honor, we plead responsible as to the failure to make payment. And then as to the anger management course, it does appear that there's been some misunderstanding. As I spoke to Mr. Cutter, he indicated that probation officer Avery Taylor had instructed him to enroll in this course, that this course was going to be satisfactory for what he needed to comply with. Again, I don't want to put words in Mr. Taylor's mouth. I know he's not here, but that was the discussion my client and I had on that issue. My understanding was that Pam's Place was where the anger management was completed, and that they had indicated to Mr. Cutter that they were emailing said paperwork of completion over, which it sounds like they must have, if everybody's in agreement that he did the 12-week class. But again, I'm not sure, Your Honor, on what happened with the miscommunication or what Mr. Taylor had said to Mr. Cutter.
And while Ms. Rapp looks at, Ms. Rapp, are you prepared to respond to that right now, or do you need to look into it?
I'm ready to respond, Your Honor.
Your response?
So reviewing the notes that Mr. Taylor did provide, he did speak about an anger management class. He reported with him multiple times, and it looked like he never did correct the defendant on the 12-week class versus the 26-week class. He has completed the 12-week program at Pam's Place.
Is that sufficient for probation department purposes, ma'am?
It's sufficient, Your Honor.
Thank you. And Mr. Hadley, as for the failure to make payments since July of 2022, you pled responsible, but what are we doing going forward, sir?
Making payments, it sounds like. Mr. Cutter and I spoke about this issue. He did indicate there's some financial tough times. He's got money kind of starting to come back in now, and he'd like to resume payments. I think, Mr. Cutter, did you say starting on the 3rd?
I can make a payment Thursday.
Thursday, okay. So, Your Honor, with that understanding, we would ask that you continue probation and let him start paying off the monies owed.
Any additional comments, Ms. Rapp?
My only comment would be, he was supposed to be off probation on December of 2022. Would you like to discharge him and then turn him over to collections?
Absolutely. There was a notation that he was, as Ms. Rapp indicated, probation should have closed December 28th of 2022. So at this time, I've heard the plea of responsible to the violation. Mr. Cutter is discharged from probation and will report to the collections department to resume payments in this matter.
Thank you, Your Honor.
Mr. Cutter,
Yes,
what you
ma'am.
can do, sir, is you can either come in person to the court and set up a payment plan with the collections department. You can go online to the court's website. On the far right, there's a contact us button. You can submit a request for a payment plan. But please do something sooner rather than later to get this matter satisfied, okay?
Yes, ma'am.
Anything else, Mr. Hadley?
No, Your Honor, thank you. Good luck, Mr. Cutter.
Thank you, sir.
Thank you, Mr. Cutter. Thank you for your patience this morning. Have a good day, sir.
You too, ma'am.
Thank you. Lieutenant Harris,
Yes, Your Honor.
good morning. How are you?
I'm wonderful. How are you, ma'am?
I am super. We are Clinton Evans.
Good.
This is 230219 SM. This is State of Michigan versus Clinton Evans. Sir, state your name for the record, please.
Clinton Evans?
Thank you. Mr. Evans, today is the day and time set for your arraignment in this misdemeanor matter. The staff has received documents from the police department indicating that you waive the right to have the assistance of the court-appointed attorney this morning. Is that correct, sir?
Yes,
You intend to complete this arraignment by yourself?
yes.
Thank you. Mr. Evans, it is alleged that on April 13, 2023, in the city of Romulus, you committed the act of domestic violence. It's alleged that you did make an assault or an assault and battery upon Jayden Ernest Lee Woods, a resident or former resident of your household, contrary to MCL 750.81 sub 2. This is a misdemeanor punishable by up to 93 days in jail, fines of up to $500 plus court costs. Sir, for purposes of the arraignment, the court will have you stand mute to the charges. There is a recommendation from Romulus Police Department that indicates that they do not oppose personal bond in this reason. They're requesting the condition that you have no contact with Jayden Ernest Lee Woods. Mr. Evans, do you have any reason to have contact or communication with Jayden Ernest Lee Woods?
No.
Mr. Evans, the court will set your bond at $5,000 personal. You do not need to post any money, but what you must do is continue to appear as directed by the court until this matter is resolved in its entirety. A condition of your bond is that you have no contact with the complainant in this case, the complainant being Jayden Ernest Lee Woods. No contact, sir, means no contact, no direct contact, no contact with third parties, no contact through social media. Should this court receive report from the police department that you've made efforts to be in communication or contact with the complainant in this case, it could be viewed as a violation of your bond, and you can spend the rest of these proceedings in custody. Do you understand?
Yes, ma'am.
The next step in these proceedings, sir, is your pretrial, which will be on May the 3rd, 2023 at 10 a.m. back here with me in courtroom number 1. Again, this is 230219 SM. Next appearance date on Zoom on May 3rd at 10 a.m. back here with Judge Martin, courtroom number 1. Mr. Evans, you have another matter. It is 1622980T Sumter Township versus Clinton Evans. The issue in this case, sir, is that you failed to appear on a driving while license suspended, revoked, or denied out of Sumter Township from May 29th, 2016. You had previously posted a bond in this case that has now been forfeit. There was a warrant issued for your arrest back on September 15, 2021. Is there a reason why you haven't come and to take care of this matter, Mr. Evans?
To tell you the truth, I've been picked up a few times on it, and the last time that I paid money on it, I was under the understanding they were just going to take the money that I paid on it, but I don't know. Obviously, this is never going to go away. I mean, I don't know. Obviously, I had a totally different understanding because now I'm here and I see it again. So,
Well,
I mean, it's something that we can talk about when I come back. Like, I mean, is it something that I have to set up another payment plan, obviously, because it seems like they just keep wanting something out of it? I mean, I don't understand. I'm totally confused with this case.
So this is, Mr. Evans, this will be a little different. The court will recall the warrant for this driving while license suspended. We'll have you stand mute to the charges. Set your bond in this matter at $1,000 personal. You do not need to post any money, but what you must do, sir, is appear. This is a different venue, sir, so it will be a different court date. You have to return to court on the driving while license suspended on May 11th at 9:10 a.m. It's back with me, Judge Martin, in courtroom number 1, but for 1622980T, the next appearance date is May 11th at 9:10 a.m. back on Zoom, back with Judge Martin.
Okay.
And then lastly, Mr. Evans, before you take your leave, there are other open cases you have with the court, sir. You owe the court a total of $1,788.17 on civil infractions and sentence cases. This is impeding traffic, allowing unlawful driver, no proof of insurance, driving without care. Please come in and set a payment plan in those matters. You can either come in person and do it, you can call and talk to the court's collection department, or you go onto the court's website. There's a drop-down button that says contact us, submit payment plan. But please take care of it. Otherwise, we're going to wind up back in this position again. So, sir, again, for the domestic violence case, I will see you here on May 3rd at 10 a.m. on Zoom. And for the Sumter driving while license suspended, May 11th at 9:10 a.m.
Okay, thank you.
Any questions, Mr. Evans?
No, ma'am.
Thank you, sir. I'll see you on May 3rd.
Bye.
This is 220158 SM. This is State of Michigan versus Sonny Cooper. Ma'am, please state your name for the record.
Sonny Lawful Cooper.
Ms. Cooper, today is the day and time set for your arraignment on a warrant issued after you failed to appear for your pretrial. Ma'am, the way the staff have you labeled indicates that you're waiving your right to have the assistance of the court-appointed attorney. Is that correct?
Yes, I do.
And you intend to proceed on your own, ma'am?
Yes.
Ms. Cooper, the court will recall the warrant that previously issued. The bond recommendation from the Romulus Police Department indicates that they do not oppose personal bond. Ms. Cooper, what concerns this court is that I arraigned you back on March 1st of 2022, gave you specific directions to appear, and you failed to appear.
I had no means.
You had no means to appear by Zoom?
Yep.
You didn't have access to a phone or a computer?
No.
Do you have transportation?
No. It was not.
How did you come in? I'm sorry?
It was not driving. It was undrivable.
Ms. Cooper, the court will recall the warrant in this matter. Reinstate your original bond, which was $5,000 personal. You are not to have contact with the complainant in this case. You are not to return to 32690 Gateway Drive. Your pretrial is reset for May the 3rd, 2023 at 10 a.m. back here with me, Judge Martin, in courtroom number 1. Ma'am, you have another matter, 1953110M. This is City of Romulus versus Sonny Cooper. This one was a violation of parental responsibility warrant issued when you failed to appear for a pretrial back on on March 17, 2022. That warrant has already been canceled. Ma'am, you are set to return to court on that violation of parental responsibility on May the 4th, 2023 at 8:30 a.m. in person with Judge Oakley. So 1953110M. That return date is May 4th, 2023 at 8:30 a.m. with Judge Oakley. Anything else, Lieutenant Harris?
No, Your Honor, we're all set. Thank you so much for your time.
Thank you. Thank you.
All
Ms.
right.
Cooper, good luck to you, ma'am.
Madam. Welcome.
Judge, I apologize. What was the bond on that 19-5311?
I'll reinstate the original bond, which was 5,000 personal.
Thank you.
Thank you, ma'am. Two 230218 FY, State of Michigan versus Ronnie Earl Brown Jr. Your appearance, please, sir.
Good morning, Your Honor. Daniel Batar on behalf of Ronnie Brown.
State your name for me, sir.
Ronnie Earl Brown Jr., Your Honor.
Thank you. Today is the day and time set for the felony arraignment in this matter. Mr. Batar, how are we proceeding?
Your Honor, I've gone over the charges with Mr. Brown. We will waive a formal reading. Stand mute, please.
Thank you. Mr. Brown, you had the opportunity to speak to Mr. Batar this morning,
Yes, Your Honor.
and you understand the charges you face and the possible penalties.
Yes, Your Honor.
Mr. Brown, you have an absolute right to be represented by an attorney in this felony matters. If you're unable to secure retain counsel through your own resources or that of friends and family, the court is able to appoint an attorney for you going forward. There was an application for appointment of attorney attached to the front of your file. The court has signed that. You will be assigned an attorney going forward. It will not be Mr. Batar. It will be someone else who uses the information you provided this morning to be in contact and communication with you. Sir, you also have the right to be considered for pretrial release. There is a recommendation in the file from the airport that requested your bond be set at 500,000, no 10%. The allegations that you have an extensive criminal history includes carjacking, burglary, receiving, concealing stolen motor vehicles, unlawful driving away cases which are being reviewed. You have warrants out of 36th District Court. You have failed to appear previously for a variety of warrants. You're currently on probation or parole. You have a lack of a permanent residence, multiple addresses having been provided. Mr. Batar, any comment as to bond in this case?
Your Honor, Mr. Brown is 21 years old. He's not married, but he's in a long-term relationship. He lives in Detroit with family members. He claims he's lived at the same address for the past 10 years. He is currently enrolled in a GED program through the Pathway Schools. That's an online program. He has a 3-year-old son. He does have priors, Judge. We dispute that he has any carjacking in his criminal history. Maybe the detective could give us more information on that. It's my understanding he had a case out of Macomb County, which was a UTA case along with burglar tool possession. He did a year in the county jail on that charge. It is correct. He is currently on height of probation to Judge Shannon Walker of the Frank Murphy Hall of Justice. That is currently under HIDA. I understand the seriousness of the allegations made in this case, Judge, but they are property crimes. There are no assaultive allegations. We're asking the court to consider something along the lines of 50,000, 10%. We have no issue with any GPS tether.
Thank you, Mr. Batar. The court has taken the opportunity to review Mr. Brown's criminal history. And while you are accurate that they are not assaultive crimes, the property crimes are upsetting and disruptive to people's lives, the court will depart from the recommendation of law enforcement and set Mr. Brown's bond at 100,000, 10%. Mr. Brown, if you're able to post that amount, you will not be released without a GPS tether for location purposes. Your next court date, sir, will be by Zoom on April the 26th, 2023 with Judge Green and courtroom number 3. Again, this is 230218 FY. Next appearance date, Wednesday, April the 26th, 2023 at 8:30 a.m. with Judge Green in courtroom number 3. Anything else in this case, Mr. Bitar?
No, Your Honor, thank you very much.
Thank you. Anything else, airport?
Yeah, good morning, Your Honor. This is Detective Joe Nace here with the Airport Police. I am accompanied by a Detective Joe Morgan from Troy Police Department. He actually has a lot of greater knowledge than I do regarding a lot of these charges. It's a pretty big, very large case, and I realize that you just did give the bond out, but is there any chance that we could possibly make comment on that? I know you did.
Absolutely.
Okay, I'm going to have Detective Morgan speak about this if he may.
Good morning, Your Honor. How are you?
I'm wonderful. How are you?
Can you sit down?
Absolutely.
Sit down or stand up? Is that fine?
No.
Your Honor,
You're fine.
I've been working on this case with Mr. Ronnie Brown since October last year. We actually arrested Ronnie in November, stealing a car in Novi, which he's currently going through court in Oakland County. And also prior to that, he's out on bond on a case out of Wayne County that was just, they just added another year to his probation. He was in court March 21st in front of Judge Matthews in the circuit court. Judge Matthews removed his tether because Ronnie said he's unable to pay the tether fee on it, so she took his tether off of him at that point. He's due to come back.
I'm sorry,
on May
back
5th.
up. I'm sorry, Detective, what's the last thing you just said?
Your Honor, he was in court March 25th in Oakland County on original case of UDAA out of Troy. I work in our surveillance unit. At that time, on March 21st, he told the judge he was unable to pay for his tether, so the judge took his tether off of him. His bond conditions out of our case is he cannot leave the state of Michigan or engage in new criminal activity. His probation conditions out of Wayne County state the same thing. He cannot leave the state of Michigan or engage in new criminal activity. Your Honor, since that date in the last 14 days, Ronnie has been in 9 states, which he is engaged in criminal activity involving stealing multiple vehicles in Pittsburgh, in West Virginia, in Virginia, Ohio. I just tracked him to Chicago, to Indiana, to Milwaukee. He received a citation a couple of days ago in Milwaukee by Racine County deputies. After that, he went straight to the airport looking to steal more cars. Your Honor, I'm going to ask until we get back to court in Oakland County, if you would entertain on looking at his bond conditions again, getting a substantial bond. If he bonds out, we're not going to see him again. He's going to continue to engage in the same criminal activity he has for the last 3 years. The case investigation is not complete. I think in a week or two, we'll have some additional charges coming, probably in multiple 8 to 10 states, probably.
Detective Morgan, I'm sorry. I'm going to cut you off I'm going to cut you off for just 1 second. You don't believe that 100,000, 10% in GPS tether is sufficient to secure Mr. Brown's return to court in this case and the other pending matters?
No, Your Honor. I believe he's going to get out. I believe he'd be a flight risk. I don't think he's going to appear in court. He's already made it clear to the judge in the circuit court he cannot pay his tether. They took the tether off. And I think he made that, it was kind of a comedy when he sent out messages with a smiley face and emoji with a teardrop on it when she took the tether off him. And that had the judge's picture on the message he sent out. I don't think $10,000 bond is enough for him. In my opinion, he's, in his own words, probably one of the main guys in Michigan involved in the stealing of vehicles and selling those vehicles, being the middleman. I would ask if you would mind entertaining a $500,000 cash bond for the time being on him, would make sure he stays in and he won't be a flight risk at that point.
Mr. Bitar, anything else?
I have nothing else to add, Your Honor. Thank you.
Thank you. Detective Morgan, once the court sets bond, I don't typically revisit it, but it is highly unusual for a detective to come on a screen and say to the court, listen, Your Honor, that is not sufficient to secure his return. And as much as part of the reason why we set bond is to ensure defendant's return based on the allegations that you have just made to the court regarding the outstanding investigations and Mr. Brown's travel over the last 2 weeks, the court will adopt the bond recommendation set forth by the airport and set Mr. Brown's bond at $500,000, no cash. His return date, the PCC date with Judge Green, will still be April the 26th, 2023, 8:30 a.m. His attorney at that time, his appointed attorney at that time may bring the matter up or address bond if they want to, if the other matters have not made you more comfortable or made law enforcement more comfortable that Mr. Brown will appear and participate in proceedings against him. Anything else, Airport?
No, Your Honor, thank you so much for reconsidering. Certainly appreciate it.
Thank you very much, Your Honor. I appreciate it.
May I talk,
Thank
Your
you,
Honor?
Detective Morgan.
Thank
Yes.
you very much.
Your Honor, I'm not a flight risk. I show up to every court date. Detective Morgan, I show up to every court date. I've been showing up to every court date on time. I have ticket court dates I might have missed, but I show up to every court date on time. And I have never missed one felony court date. And I promise you I haven't. Like, Detective Morgan say.
Mr. Brown, this is just the first
Yes, ma'am.
appearance in the 34th District Court case. What I said at the end of reconsidering your bond was that your appointed attorney can take it up with Judge Green on April the 26th, okay?
Okay, but $500, $100,000, I wasn't gonna be able to post that. $500,000, I was gonna like $100,000 gonna try to post that. $500,000, like at least can I do like 200,000, something like that, like something I could try to post. $500,000, that's just like excessive bills to me. And Detective Morgan, like, I mean, I've been very cooperative with Detective Morgan throughout this whole case, haven't I?
Yeah.
I've been very cooperative. I haven't given him any problem, anything. I was at least considered
Mr.
10% bound, $500,000.
Mr. Brown, it's not right now. It's not a matter of you being cooperative or not. This is the first appearance. This is just the arraignment. As I indicated on the record already, it is highly unusual for a detective to come on, interrupt the judge and say, Your Honor, the bond's not high enough, given what we know about Mr. Brown and Mr. Brown's history. That concludes this matter. This court will return to its probation docket. Thank you very much.
Thanks, Your Honor.
Thank you, Your Honor.
This is 220437 FY, State of Michigan versus Brandy Davis. May I have your appearance, please?
Good morning, Your Honor. Attorney Josh Hadley appearing on behalf of Probationer Miss Brandy Davis. Miss Davis, take yourself off mute and state your name for the record, please.
Hi, good morning, Brandy Davis.
Good morning. Today is the day and time set for hearing on the violation. This court has received a report from the probation department that indicates that Ms. Davis has failed to make any payment towards the restitution that this court ordered previously. Mr. Hadley, how are we proceeding this morning?
Your Honor, we're prepared to enter a plea of responsible with a brief explanation as to why payment's not been made yet.
Court accepts the plea of responsible. What's the explanation, Mr. Hadley?
Miss Davis, what was the nature of the check that you said was issued but then had to be reissued? What was that check for?
Income tax refund.
Okay, so Your Honor, there was an income tax refund that Miss Davis intends to apply towards the balance owed on the restitution amount. The check was issued, but if I understood Miss Davis right, there was an issue with how the check was either drafted, had to be reissued, and it's supposed to be arriving. When did you say, Miss Davis?
The IRS said within 6 weeks. It went to my old address and not my new address. So when it got back to the IRS, they're going to reissue a new check to my new address. What's to the correct address?
Your Honor, with that being said, we would ask that you continue probation and allow her, again, this opportunity for the reissuance of this check to take place. Again, she's on the record stating that that's what her intent is once she receives said check is to apply it to the balance owed.
Mr. Hadley, before I go to Mr. Grant for response, do you know when this occurred, this check being sent?
Miss Davis, can you answer the judge's question on when the check dates
It
were?
occurred, I was supposed to get my refund on the 3rd of April. So when I noticed that it wasn't in the mail, that's when I called them. So they stopped payment and then said I had to wait for it to get back to them for them to send it back out. That's why I agreed to have the payment in by April 3rd.
Mr. Grant, any comment?
Your Honor, I guess I would only ask that we would extend probation then because she's due to be off in less than a month.
And we'd have no issue with that at all, Your Honor.
Mr. Grant, had Ms. Davis relayed that information to you regarding the delay in making that restitution payment?
No, Your Honor, I did try calling her 2 times since we met back on March 22nd. It goes right to voicemail. I've tried sending
Yeah,
email.
I didn't have a phone at
No,
the
ma'am.
time, but I was responding back to you through the email when you sent me the email. And you told me if I have it in, then you'll cancel the court proceeding. So I responded back to you through email. So
The court has accepted the plea of responsible for failing to make the restitution payment. Ms. Davis, probation will be extended. The probation department will send out new notice of that adjourned date. The only remaining issue seems to be the restitution, which is an order
right,
of
and I had no
court.
problem making that payment. I told him I wanted to make it on the 3rd because that's the day that it was supposed to be coming. But since they got mixed up, sent to a different address, that's why I didn't pay. But I don't have a problem with paying it. I told him the amount I wanted to pay. I'm trying to get it out the way.
Ms. Davis, all
Yes,
that will
can you-
happen now is when you get that check, be in communication with Mr. Grant and make sure the restitution gets paid. If it's paid timely, if it's paid before you're scheduled to come back, Mr. Grant will just close this matter out.
Okay,
I'm
that's
not
all
gonna
I
make you
was
come to
wondering.
court to confirm that it's been paid. Just make sure it's done before you're scheduled to come back. I don't have the probation calendar. They'll send notice to you at the address we have on file, okay?
Okay, or email is fine. I respond to me. Email is a lot quicker.
Okay,
Okay,
I'm sure
thank you.
Mr. Grant will make a notation on his end. Anything else, Mr. Hadley?
No, Your Honor.
Thank you. Ms. Davis, good luck to you. I hope not to see you again.
Same here.
Uh,
Watch it leave out.
(220033) SM, State of Michigan versus Johnson. May I have your appearance, please?
Good morning, Your Honor. Attorney Josh Hadley appearing on behalf of the defendant, Mr. Deontay Johnson, who's appearing via Zoom. Mr. Johnson, please take yourself off of mute. State your name for the judge.
Hello, yes, Deontay Johnson.
Thank you, Mr. Johnson. Today is the day and time set for hearing on a violation of the terms of probation. Mr. Hadley and Mr. Johnson, the court has received a report from Anthony Grant of the probation department that indicates that Mr. Johnson failed to maintain his attendance at his 4-week anger management class, failed to appear for a previously scheduled show cause hearing.
I think that's the wrong date on that.
It is, it says September 9th of 23. Obviously, it's September 9th of 2022. Mr. Hadley, what's your
Your Honor.
position this morning?
Honestly, I think this would be a plea of not responsible. My understanding is that the anger management course, well, let me rephrase. Whether or not there was notification since probation, we can concede that, but it does appear that Mr. Johnson completed anger management last Thursday.
Mr. Grant, do you have any information regarding that? Any update?
Your Honor, I did receive an email from Mr. Johnson late Friday afternoon before that file went to you, or after that file went to you, I should say. I do have confirmation that he did attend that 4th anger management class that was required.
Your Honor, with that being heard, we would ask that he be successfully discharged from probation. It looks like fines and costs have been met, and the original end date would have been September of last fall.
Mr. Grant?
That's fine with probation, Your Honor.
Mr. Johnson, the court is discharging you successfully from probation. Anything else, Mr. Hadley?
No, Your Honor. Thank you, Mr. Grant. Thank you, Your Honor.
Mr. Johnson, thank you for your patience this morning. Good luck to you, sir. Enjoy the rest of your day.
Thank you.
This is 194496 SM. This is State of Michigan versus Ronald Nickel. May I have your appearance, please?
Good morning, Your Honor. Attorney Josh Hadley appearing on behalf of defendant, probationer Mr. Ronald Nickel. Mr. Nickel, please state your name for the court.
Ronald Nickel.
Thank you. Today is the day and time set for a hearing that had been previously adjourned on a violation. The court we were last here on March the 6th, 2023, at which time Mr. Hadley, on behalf of Mr. Nickel, entered a plea of responsible to the violations. Mr. Nickel was to resume his anger management program through the VA, provide proof of that within 30 days. There was a conversation about converting some of the fines and costs to community service, at the rate of $15 for every hour of community service completed. The information from Mr. Grant is that Mr. Nickel still has not provided documentation of the anger management
I was
and has
told
not
by,
provided 80 hours of community service or made payment. I'm sorry, Mr. Hadley.
No, I was telling Mr. Nickel, just hold on, let you finish up. But we'll have a chance to address the judge in just a second.
I finished, sir. Thank you.
Okay. So, Mr. Nickel, go ahead. I know you're trying to explain yourself. Feel free to speak now, sir. Sorry about that.
yes, ma'am. I was told by a social worker at the VA that they were going to get the anger management course paperwork over to the probation department themselves.
And Your Honor, Mr. Nickel did share with me that he did initiate the anger management classes on March 22nd. He's been attending once per week, and he's scheduled to finish the anger management courses on June 8th. In addition, what Mr. Nickel was also referencing is beyond the scope of his probation order, he's been engaging in individual individual therapy with the VA. As we discussed it, he found that the anger management course is sort of a group participation, a lot of yelling, a lot of stuff going on. So he's actually found that this individual therapy has been much more productive in helping, kind of work through these issues than the anger management. He stated that he continues or intends to continue on with the individual therapy. I know that the June 8th date isn't that far away, but we would ask for probation's input on whether or not they feel that maybe the objective of what anger management was for can be met through this VA outpatient therapy.
Mr. Grant?
Probation doesn't have any objection as long as we get some sort of documentation. We don't have documentation on anything.
Very good. Mr. Nickel, you understand that it's your responsibility. I know that the VA said that they were going to get things over, but you need to take kind of the initiative and make sure that these documents get to Mr. Grant.
Yes, sir.
Very good. Can you get those documents to Mr. Grant this week?
I will definitely be able to get those documents to Mr. Grant this week. I'll go ahead and send him an email as soon as I'm able to get the ones from the course.
Very good. Your Honor, as to the unpaid fines, we do admit that there hasn't been payment made. I do remember the discussion last time we were here about converting this into community service. Mr. Nickel and I discussed that again. He's very limited on income right now, and I do believe that why it hasn't happened till now, we can discuss obviously, but he has voiced his intent to get some community service hours scheduled and start chipping away at this, as he's aware that financially he's just not going to be able to pay that $1,219 right now.
And again, my Social Security disability and my income is around $1,100 gross per month. So it's very difficult for me to make.
Mr. Nickel, what we're asking now, though, is because last time we were here, we said that we were going to get these community service hours started. We're humbly asking that they give you some more time to do it. How soon could you get some of these hours scheduled?
I can go ahead and schedule some. I can try to get into a couple different places, but I have been working with the Al-Anon Club as well to assist them with things around there for their meetings, their resource meetings, as well as recovery meetings.
Thank you. Mr. Hadley, what this court will do is adjourn this matter one last time. And Mr. Nickel, I want to say this clearly and specifically.
Yes.
The probation department will send out notice of your new date. That date will be in approximately 30 days. If we return in 30 days and you have not provided proof of anger management treatment to probation and or either made payments towards the fines and costs or presented community service, proof of community service being completed, this court will send you to jail, finding technical violation of the terms of your probation. Do you understand what I'm saying?
Yes, ma'am.
It's an old case. We just want to get you towards being successful on probation. So if there's something that you need, if there's some support that the court can give you, do not hesitate to reach out to Mr. Grant. But sir, when you say that you have this documentation, please get it over. And if you're able to start community service, we can start moving towards having this matter resolved. Anything else, Mr. Hadley?
No, Your Honor. Thank you. Thank you, Mr. Grant. Appreciate everyone's patience and time.
Thank you. Have a good day, Mr. Nickel.
Thank you.
This is 220501 SM. This is State of Michigan versus Sheena Taylor.
Good morning, Your Honor. Attorney Josh Hadley, on behalf of Ms. Sheena Taylor. Ms. Taylor, please turn your camera on, take yourself off mute, and state your name for the court.
Sheena Taylor.
Thank you,
Sheena
Ms. Taylor.
Taylor. Yep.
Thank you. Today is the day and time set for hearing on notice of violation. We were last here on February 13, 2023, Mr. Hadley and Ms. Taylor, at which time the court reset the matter for Ms. Taylor to resume payments. There was supposed to be $100 paid within 7 days of that hearing date. And we were waiting for the disposition of a case out of the 72nd District Court. Where do things stand now, Mr. Hadley?
That matter has been resolved and taken care of. There was fines and costs paid in full, and it's been closed out with the St. Clair County.
Any comment on this case, Mr. Grant?
No, Your Honor. We only ask that she goes back on probation. She has paid off her fines and costs. She's continuing to attend her anger management. The only issue was that that pending case out of the 72nd District Court.
Thank you. Ms. Taylor, thank you for resolving the issue out of the 72nd District Court. This court will continue you on probation. Anything else this morning, Mr. Hadley?
No, Your Honor. Thank you.
Ms. Taylor, thank you for your patience this morning, ma'am. That concludes this matter. Have a good day.
You too.
And I believe
This is 21BL008480D. This is City of Belleville versus Freeman. May I have your appearance, please?
Good morning, Your Honor. Attorney Josh Hadley, appearing on behalf of defendant probationer, Mr. Tayana Freeman. Nope, there she is, Miss. I'm sorry. I've got my Freeman's crossed. Miss Tayana Freeman. All right. Thank you for your patience. Miss Freeman, can you please state your name for the record?
Tiana Freeman.
Thank you.
Thank you. Today is the day and time set for a hearing, an adjourned hearing. The parties were last here on November 28, 2022, which time the court adjourned the matter to allow Ms. Freeman time to complete her 24 hours of community service, provide documentation to the probation department. This court has received a report from Anthony Grant of the court's probation department indicating that Ms. Freeman has failed to provide proof that she's completed her community service hours. She has failed to maintain her payment plan. She has not made a payment since November 9th, 2022 and owes $928 in this matter. Mr. Hadley, how are we proceeding this morning?
Your Honor, we'll prepare to enter a plea of responsible to the probation violations with an explanation briefly.
That explanation, sir?
Well, Your Honor, I think you can hear part of it in the background. So Ms. Freeman, we were here last time, I believe we're still pregnant or had just given birth. So she's currently at home with a newborn. Recently, she also had a unfortunate diagnosis of some autism with her 3-year-old. So she just started working again a couple of weeks ago, but her hours in a day are pretty well spread thin right now. Again, it's not that she's intentionally trying to shrug off the responsibilities. I think just in the order of where her life is right now with 2 children that she's the primary caregiver for there at home, it's just been a practical obstacle. She did indicate that, again, as she started working again recently, she will be able to start resuming these payments that I see trailed off of November of last year. But as to the community service, I think we're kind of stuck in a tough spot right now for getting that done in the immediate.
Mr. Hadley, before Mr. Grant responds, the court will note that when the parties appeared back on November 28th, Ms. Freeman entered a plea of responsible to these same violations. The court adjourned the case for 4 months and advised Ms. Freeman on the record that she needed to complete the community service and resume payments, or there would be jail time. She was sentenced in this matter over a year ago now. 24 hours of community service, 2 hours a month, and she could have completed the community service. Not making payments for 6 months, it's just not acceptable. Mr. Grant, was there something you wanted to say, sir?
Nothing that you haven't already said, Your Honor. I was just going to mention that it has been adjourned 2 separate times for the same reason. And as you explained, it's been over a year to complete the 24 hours of community service. So probation department was asking for jail time.
How much jail time, Mr. Grant?
1 day of jail time for the 24 hours of community service.
Mr. Hadley?
Again, Your Honor, we understand everyone's position on this, but looking at the situation that Ms. Freeman's in, arranging for childcare, I understand it's just a day in jail, but that's a pretty, it's a pretty heavy, penalty for this individual specifically to pay. We would ask the court just consider the circumstances that she's in, and we'll leave it to your discretion.
Thank you, Mr. Hadley. The court's concern is that, again, Ms. Freeman appeared on April 4th, 2022. Fines and costs were assessed. Community service hours were assessed. She would have been a participant in these proceedings, indicated the ability to do what the courts asked her to do. And for her to do nothing since November, it's just unconscionable. It's our agreement that we live together in this society. When the court imposes a sentence, that you will do something. And I'm sure that Mr. Grant or someone else from the probation department has made efforts to be in communication with Ms. Freeman regarding these hours and regarding the payments that need to be made on these fines and costs. The court does not take lightly sending anybody to jail, but how many times can a case be adjourned and a defendant who agreed to a certain sentence does nothing? Ms. Freeman?
Hello.
Yes, ma'am.
Oh, Your Honor, I really wanted to get my community service done, but like my attorney has said, it has been hard. It has been rough. Finding out that my 3-year-old has special needs and then having a newborn. I have been calling around trying to get the community service even done in Belleville, which it was the pandemic and a lot of things that they gave me the list was closed. So they did tell me that I could do it in the Washtenaw County area. It's just, yeah, I'm definitely trying to get it done.
Ma'am, in the 5 months since you were last here, how many hours of community service have you done?
I honestly just have 4 hours done.
You have
and I was
4
supposed
hours
to go,
done?
I have 4 hours done. I was supposed to go back to the community center, which I never made it back.
Did you send proof of the 4 hours to Mr. Grant?
Yes, I can get that.
No, did you?
Oh, no.
No, knowing that you were scheduled to come to court today and knowing that jail was a possibility, you did not respond to Mr. Grant and send proof that you have done 4 hours of community service?
No, because I didn't have the whole 24 hours done, so I didn't.
Do you have proof right now that you've had 4 hours done?
Yeah, I think I got the paper.
Yes?
Yes.
You have proof. Send that proof to Mr. Grant right now.
Okay. Do that.
If you need a few moments to do that, ma'am, I could take a recess.
I do.
Okay. It's now 10:27 by this court's clock. I'll recall the case at 10:45, ma'am. If you have not presented proof to Mr. Grant, satisfactory proof that you've done at least some community service, it will be an order of the court that you report to jail within 48 hours. So I will be back out at 10:45. Thank you.
Thank you, Your Honor. Ms. Freeman, you understand what she was saying, right? You need to find that, the proof of those
Yeah,
4
I'm
hours.
not, I gotta look for that.
Yep, find that and email it over to Mr. Grant when you find it, okay?
Okay, thank you.
Thank you, Mr. Grant. Hey, Mary Ann, are you there? I had a quick question for you.
Yes, I am.
Going back to the matter, Sheena Taylor that was called earlier,
Right.
do you know what her original charge was?
I show DV, but let me look.
That's fine.
Okay.
When I looked her up, the only thing I could find was a handicap parking ticket. I knew this wasn't it, so that
okay.
helps.
Yeah.
Thank you.
You're welcome.
This is a recall of 21BL008480D. Belleville versus Freeman. Mr. Grant, did you receive an email from Ms. Freeman?
I have not.
You did not?
Negative, nothing from Miss Freeman.
Hello?
Yes, ma'am.
Oh, okay, so the community center, the guy that oversees community service won't be back in until the 19th.
Ms. Freeman, this court will adopt the recommendation of the probation department, sentence you to 1 day in jail for violation of the terms of your probation. You have 48 hours to present yourself to jail to serve the 1 day.
Well, I don't know. I can't, that won't be possible.
Ms. Freeman, it's unfortunate. It is not something that this court does lightly. But when you appear in November and the court gives you additional time to do what you were ordered to do a year ago, and you don't do it, you don't do any part of it. And when I asked you, did you have something to show the court that you had done any community service hours, you said yes, but you led the court to believe that you had something in your possession.
Well, no, I was gonna submit an email, but I can't submit an email if someone's not in office. How am I supposed to submit anything if they're not there?
Because Ms. Freeman, you knew why we were here this
Oh
morning.
my
It wasn't a
gosh.
surprise. It wasn't a surprise why you were coming to court. You knew exactly why we were here this morning. If you knew you had to get it, you could have gotten it last week. You could have gotten it when there was notice first sent to you regarding the return court date. Anything else this morning, Mr. Hadley?
No, Your Honor.
Thank you. That concludes this matter, and that concludes this court's docket for the day. This court stands adjourned.
All right. Thank you very much, everybody. Have a good day.
Thank you, Mr. Hadley. You as well.
See you, Josh.
Andy, do you have anything else in the hopper?
I do not, Judge.
Thank you. I'll take us down. If something happens, we'll log back in. Thank you, Mr. Grant.
Thank you, Your Honor.